Good morning to students. Today you are all aware that our colleague judges are available here. All are here and we start the function. Now the topic of today everybody knows. It is a mixed constitutional and narcotics. Mr. Bhavana has rightly chosen the topic that combines the constitutional law as well as narcotics. Let's proceed for the debate.
The council seeks permission to proceed to the dais. If it may please the Honourable Court, the Council seeks permission to address the bench collectively as your Lordships. Much obliged, your Lordship. This is the Council appearing on the behalf of the petitioner in the instant matter of Mr. Y versus LCD, Mr. Z versus the State of Mumbai, and Mr. X versus the State of Mumbai. All the three petitions have been clubbed together by the Supreme Court for a collective hearing. Your Lordship, would you appreciate a brief perusal of facts?
Yes.
Your Lordship, the first petition is an SLP which is instituted by Mr. Y, who is aggrieved by the punishment prescribed under Section 8 and punishable with Section 21 of the NDPS Act. He is further challenging two rules of the NDPS Act. First, the punishment prescribed, the disproportionality of the punishment prescribed under Section 21C, and second, the presumption of culpability under Section 35 of the NDPS Act. Your Lordship, the second case of Mr. Y, the writ petition has been filed by Mr. Z, who has been charged under Section 65 Clause B, Section 65 Clause E, and 65 Clause G of the Maharashtra Prohibition Act. He is challenging that the said sections are violative of Article 19, 29, and 25 of the Constitution of India. Your Lordship, the third case is also a writ petition filed by Mr. X, who was aggrieved by the denial of the anticipatory bail by High Court and thus challenging the constitutional validity of the said section. Your Lordship, if the facts are clear, the Council would like to proceed with the arguments. Much obliged, Your Lordships. Your Lordships, in the instant case, there are 6 issues in front of the court. I shall be dealing with the first 3 issues, while my co-counsel will be dealing with the rest 3 issues. Your Lordship, for the convenience of the arguments, I shall be dealing with my issues in 3 broad submissions. First, regarding the maintainability of the petitions filed. Second, regarding the constitutional validity of the punishment prescribed. And third, regarding the constitutional validity of the presumption of guilt under Section 35 of the NDPS Act. Your Lordship, with the permission, I would like to continue with the arguments.
Yes.
Much obliged, Your Lordship. Proceeding with the maintainability of the petitions, under Article 136 of the Constitution of Indiana, it is mentioned that SLP can be sought against any judgment, sentence, decree, or order by a tribunal or a court if there exists an exceptional circumstance, exceptional or special circumstance, and there is an involvement of substantial and grave injustice. Your Lordship, this has further been affirmed in the case of Kunyamat versus the state of Kerala. Your Lordship, in the present case, there is an exceptional condition and a question of grave and substantial injustice, Your Lordship, as the fundamental rights of the petitioner under Article 21 and 14 have been violated. Your Lordship, said the 2 conditions, that is the culpability of the mental state and presumed culpability of mental state under Section 35 of the NDPS Act is arbitrary as it is against the cardinal principle of criminal jurisprudence, Your Lordship. Further, the disproportionate amount of punishment prescribed under Section 32B of the NDPS Act is also violative of Section 40 and 21 of the Constitution. It is further submitted before the Supreme Court that the punishment prescribed in Mr. Z versus the state of Mumbai, that is our second case, is violative of the fundamental rights of the petitioners. Your Lordship, in a case of Kavalappara Kottarakal versus the state of Madras, it was affirmed that Article 32 must be entertained if there exists infringement of fundamental rights, actual or threatened, and is alleged or prima facie established. Your Lordship, in the present case, Section 65 Clause D, 65 Clause E, and 65 Clause G of the Maharashtra Prohibition Act puts restriction of practicing the culture of the minority community of the Doka village, and thus violating the fundamental rights of Mr. Z under Article 19, 25, and 29 of the Constitution. Lastly, concerning the third petition, it is submitted before the Honorable Supreme Court that.
Counsel, now just explain to this court what are the fundamental rights are violated in the future.
Indeed, Your Lordship. Your Lordship, in the first case, the fundamental right under Article 14 and 21 have been violated, and the first case is what I am dealing with. Your Lordship, Article 14 talks about equality and equality and equal protection before the law. Your Lordship, in the present case, punishing a person with higher than the minimum punishment under Section 32B of the NDPS Act, and Your Lordship, the presumption of guilt which is mentioned in Section 35 of the NDPS Act. It is arbitrary in nature as it is against the cardinal principle of criminal jurisprudence which talks about a person is innocent until proven guilty. Your Lordship, in our case, the person who has no intention of supplying the narcotic.
That is the main crux of the matter, mental condition. His mental condition was such because nobody knows that in the car something will be there. His mental condition was that he is unaware of anything, and therefore you have to write to approach to the Supreme Court because of the fact that you were in the jail, and you have to approach for anticipatory bail and all that, and therefore you mean to say that you have rightly gone there under Article 136 of the Constitution.
Indeed, Your Lordship.
Yes.
Your Lordship, in second case also, which will be dealing with by my co-counsel, the fundamental rights have been violated, will be proved by my co-counsel. Your Lordship, in the third case also,
Counsel, if you have the second case, I have query. What was the reason for you to choose this court under Article 32 and you didn't prefer High Court? Like, could I have approached the High Court Article 26 as well or not? Among your response.
Your Lordship, the Supreme Court is the apex body, and approaching the Supreme Court under Article 32 is what my clients have considered the best for them. Because under Article 32, the writ petitions can be filed, and we have filed writ petitions under Article 32 of the Constitution.
So according to you, you could not have approached the High Court?
We would have.
Or according to you, 32 is better remedied in 26?
No, Your Lordship, even approaching High Court is viable. We can approach High Court under Article 226. But Your Lordship, the present petition has been filed under Article 32 of the Constitution, as it is mentioned in point number 36 of the fact. So Your Lordship, under 34 of the fact, it is mentioned that the matter has been filed in the Supreme Court. Because Your Lordship,
The same question falls on the third case as well.
Your Lordship, in the third case, the High Court has denied the anticipatory bail. That's why we have approached the Supreme Court under Article 32 for granting anticipatory bail to the client. Your Lordship, with your permission, if I may proceed.
Please.
Much obliged, Your Lordship.
Directly say that since the release of the culprit was involved, therefore you have to approach the Article 32.
Yes, Your Lordship. Your Lordship, it is further submitted. Moving to the next issue, Your Lordship, regarding the punishment Act. The punishment prescribed by the NDPS Act is arbitrary and violative of Article 14 and 21 of the Constitution of India. The factors that have to be taken into account while imposing higher than the minimum punishment, as stated in Section 32B of the NDPS Act, is absent in our case, as it is clearly mentioned in Moot Proposition number, para number 21 of the proposition, Your Lordship. If I may read it for you.
Yes. Paragraph.
Paragraph number 21, Your Lordship. Your Lordship, in paragraph number 21, it is stated that the court stated while imposing higher than the minimum punishment in the absence of proof of factors mentioned in section 32B, the court may also consider other circumstances that may seem fit. So, Your Lordship, it is mentioned here that it is an absence of factors mentioned.
Just explain to this court, what are those reasonable grounds which are required, which are necessary under 32B?
If I may read from the NDPS Act, Your Lordship.
It's not required, you can just
Yeah.
read the code.
Read, Your Lordship. Your Lordship, the main points that is relevant to our case is that the offence should not happen in the vicinity of an educational institution. Second, the person should not be a part of the crime syndicate. And third, he should not be involved in any physical violence related to the NDPS, related to the drugs. Your Lordship, in the first two situations that I stated, it is very important in present case because here my counsel of the respondent may context that it was found in the vicinity of the education institution, that is St. Mary's. But Your Lordship, in our case, he had to go through that road because he had to deliver the consignment from Mumbai to Shambhala, and in between the road St. Mary came, and it is like inevitable that how would he just have dodged that path, and thus there is no ground that section 32B has been fulfilled. Further, Lordship, he was not a part of the crime syndicate because he was misled by Mr. A.
Alright. Do you quote any relevant authority in support of your argument?
Indeed, Your Lordship.
Gyan Singh's case.
Yes, sir. Yes, Your Lordship, in Gyan Singh, it is stated that more than the prescribed punishment should not be given. Higher than the minimum punishment should not be given. It is against the fundamental right. But Your Lordship, I would also like to state the case of Rajkumar Vajpayee versus the state of UP, where the court held that without adverting to the factors mentioned in 32B of the NDPS Act, court could not impose higher than the minimum punishment. Your Lordship, thus giving higher than the minimum punishment in the present case is violative of Article 14 and 21, Your Lordship, because this is striking at the equality and liberty of a person. Your Lordship, if you may permit, I would like to proceed.
Go ahead.
Your Lordship, in the present case, the petitioner did not willfully and or with the knowledge commit the act. Thus, treating the petitioner with the same gravity of punishment as it is meant for the serious offenders of the crime is violating the constitutional guarantees, Your Lordship. Your Lordship, no one shall be deprived of life except by the established procedure of law. The arbitrary and ill-defined punishment that treats different degrees of offences under the same purview is violative of the said sections.
Counsel, please give this bench 5 points why you think that your client's punishment sentencing should be reduced. Give 5 points.
Thank you for the question, Your Lordship. The first point that I would like to mention is that the factors under section 32B has not been fulfilled, which is clearly mentioned in Moot Proposition 21, paragraph 21. Second point is that presumption of culpability under section 35 of the NDPS Act is arbitrary, as it is against the cardinal principle of criminal jurisprudence.
Counsel, what is you're saying is a proposition you would have to argue. I'm saying from the facts, why do you think that your client's sentence should be reduced? Right? You're challenging section 35, I've seen that. But I'm asking on facts, why do you think that it should be reduced?
Thank you for the clarification, Your Lordship.
If you challenge 35, you are not challenging 35, so you are admitting 35 is legal. If 35 is legal, then onus is shifting on you.
Your Lordship.
Presumption, law presumption will be against you. How do you meet that presumption?
Thank you for the question, Your Lordship. I'll be taking it when I'm discussing the 5 points.
And also, I don't think 35 has been challenged before the High Court. I mean, the challenge for the first time in the SFP.
No, Your Lordship. Your Lordship, we have challenged that the presumption of guilt under Section 35 is unconstitutional as it is voided.
Have you taken this in SFP? You can't take that. Right?
So we have taken an SLP.
In SFP.
Yes, Your
You have
Lordship.
taken that point that 35 is.
Yes, Your Lordship.
So please proceed.
Your Lordship, in the present case, the conscious possession is absent. Your Lordship, for a conscious possession, the important points to be kept in mind is that there should be an intent, motive, knowledge of fact, belief or a reason to believe in a particular fact. And Your Lordship, in our present case, all these conditions are absent because because Mr. Y considered Mr. A as a person with a legitimate business.
Counsel, when Mr. X, you client is Mr. Y, right?
Yes,
So
sir.
if he had that 400 gram of morphine in his possession, this can be termed as constructive possession. Do you agree?
Your Lordship, the consignment was found from the dicky of the car. Your Lordship, the car was of Mr. A, not of Mr. Y. So, Your Lordship, the constructive possession was also absent because in the section 35 it is mentioned that the conscious possession has to be there.
Counsel, do you have anything to show to prove that Mr. Y, your client, didn't have knowledge or information about the substance in the car?
Your Lordship, point number 13, 14 and 15 all talks about the said fact. Your Lordship, in point number 15 it is written that Mr. A successfully passed himself as a businessman and convinced Mr. Y that he was running a legitimate business. Your Lordship, and in point number 13, he introduced himself as a medical supplier and that had license from the government. And Your Lordship, nobody questions the license from the government. If you have seen that you have license from the government to transport things, then it is valid. Your Lordship, further, in point number 14, also it is mentioned that the consignment was to be delivered untampered and intact, which means he had no physical control over the goods, Your Lordship. Thus, Your Lordship, in the present case, the punishing a client under section 21 clause C of the NPS Act is violative of Article 14 and 21 of the Constitution, Your Lordship. Your Lordship, because 21 clause C puts our client under higher than the minimum punishments code. And Your Lordship, this is against Article 14 and 21 because under the Constitution.
Your crux of the argument is entire mischief was done by A. Entire mischief was done by A and it was his material, not yours.
Indeed, Your Lordship, but the main point of contention is that in this case, Mr. A has not been charged under any section, and we are not talking about Mr. A, while an innocent person is being charged. Your Lordship, if I may continue.
We will prosecute you. Don't worry.
Indeed, Your Lordship. Your Lordship, in a famous judgment of P.P. Roy versus State of Tamil Nadu, in the words of Justice Bhagwati, from a positivistic view, equality is antithetic to arbitrariness. In fact, equality and arbitrariness are sworn enemies. Your Lordship, I am not here to term anything good or bad, or to ponder over but I am here to ponder over the fact that the provisions in the given act, there are certain provisions in the given act which are arbitrary in nature. Your Lordship, thus, as Justice Bhagwati said, arbitrariness is antithetic to equality, Your Lordship, and equality is the way of
Also, with all these quotations, you will have to relate to your problem.
Indeed, Your Lordship, and in our case, Your Lordship, Article 14 has been violated as giving a person who has not done any crime, equating him to a person who is a serious offender, who is an actual offender, is against the equality, Your Lordship.
So, according to you, Mr. A should be also given equal punishment.
When I say serious offenders, I'm not talking about Mr. A. I'm talking about every offender who come under the purview of the section 32B and 35 of the NDPS Act, Your Lordship. There are people who are in actual possession of the goods or are actually transporting the goods. They are also charged with the same section when the person who has unintentionally committed something.
Counsel, do you realize that in your case one, there is a big cartel of narcotic substances, so it has a social impact. So therefore, the lower court had, the high court had felt it appropriate to give a higher punishment. Do you reply to that?
But Your Lordship, giving an innocent person such a high charging with such a high sentence, higher than the minimum punishment, is not constitutional, Your Lordship, because Supreme Court is the apex body. It is the protector of the people. He should protect innocent people.
Counsel agrees, you agree that there should be punishment. Punishment is right, but it is high. So what should be the limit of that?
Your Lordship, in my case, I am maintaining that my client.
Say complete acquittal.
Yes, sir, I'm going to say. Your Lordship, in our case, I am admitting that there is no offense done by Mr. Bai, and he was not knowing about this fact. Your Lordship, I am challenging section 30. Since I am challenging section 32B, I have to come with the point that it was higher than the minimum punishment. But Your Lordship, in our case, we are standing here to defend Mr. Y and seeking the acquittal of Mr. Y because said sections and said punishment are violative of Article 14 and 21.
All right, your time is over, that will go counsel.
Yes.
I would like to request the lower counsel.
Let us come to defense. Who wants to convict you?
It was an honor pleading before you, Your Lordship.
Second.
The council seeks permission to approve the matter.
Yes.
Warm greetings, Your Lordship. The council seeks permission to proceed. Much obliged, Your Lordship. Your Lordship, in the present case, the council will be addressing last three issues in two broad submissions. First, that the punishment prescribed under section 65 clause B, 65 clause E, and 65 clause G of Maharashtra Prohibition Act in the case of Mr. Z versus the state of Mumbai is violative of Articles 19, 25, and 29 of the Constitution of Indiana. And second, that Section 37 of the NDPS Act bars the application of Section 438 of CRPC and is constitutionally invalid. With the permission of the Lordship, the Council would like to proceed with the first submission. Much obliged, Your Lordship. Proceeding with the first submission, which is the punishment prescribed to Mr. Z under Section 65 clause B, 65 clause E, 65 clause G, is clearly violative of petitioner's right guaranteed under 19 clause 1 subclause A, 19 clause 1 subclause G, Article 25 and 29 of the Constitution of Indiana. The Council submits that in the case of National Legal Service Authority versus the Union of India, it was held that Article 19 clause 1 sub. Your Lordship, in our proposition, it is clearly mentioned that bhang has been used by the farmers as their expression of joy, and they use it as when the harvesting festival comes to thank their local deity. Hence, it is a well-established practice under religion and culture as well. Therefore, it is only for the one day. And for the preamble of Constitution of India, that inter alia speaks of liberty of thought, expression, faith, belief, and worship. Therefore, it is well established.
All right. You mean to say if any practice is part of religion, that itself has got a license to consume it, even if it's part of NDPS Act?
Your Lordship, that is our main condition here. That cannabis, which is the bhang in our case, specifically talking about the seeds and leaf part, is not mentioned in NDPS Act.
Council, if you look at Schedule 1 part 1 of NP 2, cannabis is specifically mentioned, which is prohibited substance, right? The narcotic drugs. It doesn't qualify whether leaves will be part of it. That's the basis of you saying that leaf is exempted from NDPS Act.
Your Lordship, referring the same section,
Please come to your schedule 1.
Your Lordship, referring the same section of NDPS Act, that is section 2, clause 3, subclause B. It is clearly mentioned that ganja, that is the flowering or fruiting top of the cannabis plant, excluding the seeds and leaves, were not accompanied by the tops, by whatever name they may be known for, it is designated. It clearly means that they are exempting leaves and seeds part. And further, there are specific names of cannabis that can be ganja and other. So we cannot infer that here the farm is illegalized. Therefore, NDPS Act clearly omits. And further, the Council would like to bring to the Board's notice that the Indiana also ratified the Single Convention on Narcotic Drug Treaty, in which it was where cannabis had been classified as a hard drug. But when Indian delegation came to that to know about the treaty, it clearly opposed the treaty, stating the social and cultural use of bhang in India. Because as the council points out that in Varanasi itself, the state sells the bhang, which is a legal practice. Hence, here the right of Mr. Z is clearly violated. Further, Your Lordship, coming to the Article 25 of the Constitution of Indiana, the Supreme Court in Tilkaya Shri Govind Lalji Maharaj versus the state of Rajasthan held that the test determining in question of law what is considered as an integral practice of religion is upon the community to decide who practices that religion. The traces of this judgment is also seen in the dissenting opinion, which is a very famous opinion of Justice Indu Malhotra in the case of Shravanimala, that it is upon the community to decide what is an essential religious practice and not upon the court. Therefore, it is contended that the people of Doka village have accepted this as a valid practice. That's why they have been following it since time immemorial. Thus,
Alright. I have a question. To establish any custom or practice, a valid custom, there are certain essentials. One you have already spoken. What is another one?
Your Lordship, to practice a custom as a law, therefore there needs to be a continuity. Further, that
Okay.
continuity should be followed.
And your problem, for 2 years, it was discontinued for the reason of COVID-19, which is given in your proposition. So what are you going to consider it? Continuity or discontinuity?
Your Lordship, the continuity in our case is not followed because of the exceptional circumstances that can be given. That is what that was the act of God, and no one could to interpret that. And therefore, this continuity to preserve and to conserve the same and to keep their tradition alive. Mr. Z in the
This court would like to listen from your mouth. What is the exact word, under what circumstances this continuity is also considered continuity?
Your Lordship, talking about the essentials. Number one, antiquity. That is, it
You
has
have already spoken, need not to repeat.
then reasonableness. The third essential is reasonableness.
I'm only talking, this court only want to know about continuity. Rest need not be touched.
Your Lordship, in our present case, the exceptional circumstances of COVID-19 should be taken into consideration because it was not upon the discretion of the people of Doka village to not continue the practice. They were willing. That's why, as soon as the conditions were good, they urged to the state that to allow them under the purview of the state to practice the thing. Therefore, it was in the interest of general public itself that they discontinued the practice for 2 years. Otherwise, spread of COVID-19 would have been there. Therefore, it was an exceptional circumstances, and hence it cannot be regarded as
Was
discontinued.
it beyond your control, beyond the control of your client?
Indeed, Your Lordship, the exception
That's
that
what I said. Carry on.
Also, you realize that today, if this court decides that there should be some exemption for Doka village, and tomorrow other villages also claim that they are the same thing. So it may turn out that after after decision, then maybe 100 villages are coming up with the same proposition, that then they're saying that cannabis should be regularized for some occasional purposes. You realize the social impact. So, what would be your response to that?
Your Lordship, thank you for the question. The Doka village has a distinct culture which is protected under Article 29, that is the council is contending over it. The rest of the village might not have a distinct culture, they take cannabis as the enjoyment purpose. Further, in our case, it has been established that it is from since time immemorial, and speaking from the mythological aspect, the traces of this bhang is also found in Atharvaveda, and further, Lord Shiva also uses the same. Therefore, in Varanasi it is also valid, and in UP and Punjab as well the consumption is valid.
Mr. Councilor and Ms. Councilor, you are talking about a particular community. What happens, there's some other community in that particular village, they may have some objections to the usage of cannabis, right? May not be used to consumption of this. So how do you pose a balance for that? If you have to allow that, which violates the rights of other community, then what will be the response to that?
Your Lordship, Indiana is signatory to International Convention of Economic, Social and Cultural Rights. Therefore, it is stated that everyone has a right to conserve their culture, and in the Doka village, the entire community is the part of that. Therefore, no right can be traced out, and any mother community could get into the infringement. Further, Your Lordship, the MPA Act has been enacted in 1949, which is time back from the today, and it has been stated that clearly in the whole proposition, tourism is a very good point there in the fair of the village. Therefore, it is contended that it is under the state's purview already. Because when there is a point of contention of tourism, the state comes into picture. Thus, it was under the purview of the state that this practice has been followed. And it cannot be termed that any other village or any mother community could get the infringement because they have a distinct culture and they have a right to protect the same.
Ms. Consul, how do you say that you have a distinct culture from the other villages? What is the basis you are going on?
Thank you for the question, Your Lordship. Your Lordship, in the mood proposition itself, it has been mentioned that the festival of Yoli is clearly specific to the people of village Doka. That is the mood proposition number, para number 23 and 24. That it is specifically to the restricted to the people of village Doka, and nowhere else in Indiana or any other where in the world it is celebrated. Thus, if such practices is restricted, the whole tradition and the whole culture practices would go in with and would extend. Therefore, to preserve the same, their lives are rights of tradition. If your lordships are satisfied and have no further queries, I would like to move to my second submission.
Please.
Your Lordship, proceeding with the second submission, the Council submits before the Honorable Board that Section 37 of the NDPS Act bars the application of Section 438 of CRPC, that is unconstitutional. Your Lordship, it is contended that the rationale behind enacting Section 438 of CRPC was to safeguard the personal liberty of individuals. And it is clearly mentioned under Clause 1 of 438 that if it may deem fit, that is, if the legislation gives the discretionary power and unfettered power to High Court to grant anticipatory bail, because the Article 29 which talks about life and liberty is very enlarged and nobody would be deprived of it. Further, the bar upon the same by 37 of the NDPS Act defeats the very purpose of the legislature of enacting this CRPC.
But Council, if there is a special act, it did not override the general.
Thank you for the question, Your Lordship. The Council here is not contending to override the Act. However, it is not contending also to struck down the Act. The Council here is contending to read down the Act. Therefore, the Section 37 of the NDPS Act should be relaxed. Further, so that the main aim of anticipatory bail, which was to give the influential personality a bail in the apprehension of arrest. The Council comes that the bail is a right and it should not be deprived of. Further, the petitioner here, Mr. X, is a very influential personality and have a very great say in the economic of Indiana. Further, his conviction would lead to various bad impacts in the society. Thus, to save the same, it is very important that it should not be deprived of.
My question is, when there is a special act, why providing for special treatment to deal with the offense, which again is of special. You know, the narcotics have the habit making thing. Now that habit making offenses and the offenders who are supplying the material are sought to be treated by this special act. Then why the special act should not prevail over the general act? General act is not dealing with the special circumstances.
Thank you for the question, Your Lordship. Your Lordship, that is what the council is contending in the present case, that our petitioner is not charged or liable of any of the offence, because under section 37 itself there are two conditions which states that if a prosecutor feels that the person is not liable of the offences charged, and second, that he is not likely to commit offence any of the way. Further, I submit that our petitioner, which is Mr. X in the present case, has not done any offence, which means he is eligible for the bail. Further, that he is likely to commit any offence of the bail could not be presumed.
What you are suggesting is that your client is not coming within the purview of section 37. Therefore, you are entitled for the judgment.
Indeed, Your Lordship.
But you have been charged.
Your Lordship, that charge is clearly arbitrary and violative of Article 21 of the Constitution of Indiana, because in our case, Mr. X has not been committed the offence. Since the possession of the contraband lies with the ship person, and ship is not owned by Mr. X. However, only the ports are owned by the Mr. X, and whatever ship come and go there are various possessions. The possession cannot be established, neither corpus nor animus. Hence, the petitioner is not liable under the said charge. Therefore,
There was a previous occasion also when the similar incident happened. Like there was a seizure of some substance in at the spot. So there's a possibility of presumption also that Mr. X may have been involved with the offence, the procurement, possession, or transport of the goods. How do we rule out completely?
Your Lordship, the previous charges that he has been charged of was tax evasion cases, and those tax evasion cases could not be equated with the very heinous offence of drug. And here the Cardinal Justice of Criminal Jurisprudence lies that he is innocent until proven guilty, because what needs to be established is prima facie grounds which are absent.
As my brother Chris has already pointed out, see, NDPC is a special act. So when you have a provision for punishment and certain criteria have been laid down, how do you equate with CRPC provision, given the fact that legislative intent, which is clear from section 37, starts with notwithstanding anything contained in CRPC, right? There's an intention, if you look at the objective of the act also, for certain specific purposes this act has been created. So if you are bringing down, lowering it, the parameters and trying to similarize with CRPC provision, I think we'll have a problem in implementation, right? So how do you respond to that?
Thank you for the question, Your Lordship. Your Lordship, first of all, the council contends that section 37 is not attracted because he has not done any offence. That is how further prescribing punishment to him under section 37 is arbitrary, because in very case law that this court has affirmed.
Rohit had asked another question. You are again repeating the same thing which you have already asked. Talking about non-offset clause, given over here.
Your Lordship, to answer the question, the very objective of the NDPS Act when it was amended in 2001 was to rationalize the punishment. However, in our case, we cannot find any rationalization, because since he has not committed the offence, there's even after that fulfilling of the condition of section 37 also, he has been charged. And Your Lordship, it is contended that section 438 of CRPC and Article 21 of the Constitution of India go hand in hand. Thus, deprivation of one leads to deprivation of another.
Thank you very much. Your argument should be that at least A should have been a co-accused. At least, because the court belongs to him.
Your Lordship, A should be the accused but not Mr. Y. And secondly, Mr. Z has the right to protect his culture. And thirdly, that Mr. X has the right to get anticipatory bail, and denial of the same is constitutionally invalid. Thus, I would like to proceed with the prayer.
Okay.
Please come on the prayer.
Yes.
In the lines of issues raised, authorities cited, and argument advanced, the counsel for the petitioner humbly prays that the Honorable Court be pleased to adjudge forth and declare that present petitions are maintainable, that the punishment prescribed to Mr. Y under Section 32 Clause B and Section 35 of the NDPS Act is clearly violative of Article 21 and 40 of the Constitution of Indiana, that punishment prescribed under Section 65 Clause B, 65 Clause E, and 65 Clause G of Maharashtra Prohibition Act is violative of Articles 19, 25, and 29, and Section 37 of the NDPS Act bars the application of Section 438 of CRPC and is constitutionally invalid, and or pass any order that is in the act of justice, equity, and fairness. And for this act of kindness, the counsel for the petitioner shall duty bound to pay for it. It was an honor meeting before you.
Thank you. Yes, defense counsel. Yes, come on. Why you want to implicate X unnecessarily, no mens rea, nothing of the kind? Yes. You have already submitted.
My Lord, am I audible?
Yes.
Good evening, my Lord. This is the counsel for the respondents, and I am here to award the respondents in the matters present before the court. The counsel seeks permission to address the bench individually and collectively as your honor. Not just that. If it may please your honor, the counsel seeks permission to admit the bench to the facts of the case.
Facts are already clear, come on.
If you can just tell me how your co-counsel have segregated the issues.
Your Honor, for the convenience of the court, what we have done is that there were issues 1, 2, 3, 4, 5, 6. As per the new proposition, we have changed the order. So I will take you the maintainability of the petitions before the court, and then whether section 65B, E, and G of MPA 1949 are violative of Article 14.
You can just give the issue number.
Your Honor, first, 4th, and
First, fourth, and
yes, sir. And my co-counsel shall be given the triple second, 3rd, and 6th. Your Honor, I just wanted to add something to the facts. So, may I have the chance to see the facts again? Is it my
Yes. Proceed on your own way, as you have prepared.
So I would like to bring you to the notice of the court that Mr. Y is a tuition teacher. So he's a reasonable man, he is an educated man, and he himself volunteered to get into this cartel by agreeing to work for Mr. A when he was in Wonderland. Thus, we cannot believe that he reasonably had no idea, even the fact sheet mentioned that there was a modus operandi, and given the background of Mr. Y, there could have been no instant that he had no idea of modus operandi. So we cannot say that he was in no knowledge or had no idea about what Mr. A was doing. The second, Mr. Z is a vendor. So he was selling thandai. Thandai was laced with cannabis leaf. So under the Maharashtra,
You are on issue number 1 first?
I'm not understating the facts in brief.
Counsel, we may have some time to maintain the first issue. First facts, we may find that, can you please directly come to fact 2 and 3, case number 2 and 3, how you contend that this will not maintain?
We don't want to discuss on Mr. Y's.
If you can have the second and third first, we move ahead.
So, Your Honor, the second one is a declaration that has been filed by Mr. Z, who is a vendor. So we are arguing that he was selling a prohibited substance under the Maharashtra Prohibition Act. So, before I begin, I would like to give you an introduction of the plant that we are talking about. So the plant that we are concerned about is called Indian hemp or cannabis sativa. So there are certain parts of which are prohibited under the NDPS Act. And section 10 of the NDPS Act gives the power to state legislatures also to either completely prohibit the substance or to make certain laws with regard to regulation and other things. So there are certain states that have allowed commercial cultivation like Uttarakhand, and there are certain states like Maharashtra. What they have done is, so there is this complete plan. Under the NDPS Act, only the flowering crop or the fruits are banned. They are constituted as ganja. They are called ganja under the NDPS Act. But in Maharashtra Prohibition Act, they have added the provision of cannabis leaves also. So under the Maharashtra Prohibition Act, cannabis leaves is also prohibited, and the state has the power to do that. So we are humbly submitting that whatever has happened to the petitioner has happened under the due process of law. So Maharashtra Prohibition Act clearly says that consumption, selling or dealing in this particular portion, that is bhang clubbed with cannabis leaves, is a prohibited act, and you are not supposed to deal in it. So he was dealing in it, and thus he cannot seek protection under Article 91A and 91G4. Secondly, he is asking for the protection of the same right under Article 19 also, and then Article 25 also. So these two rights are not only mutually exclusive but also denied. My lord, the second submission in this context is that no fundamental right is touched. Article 91A also has restrictions, Article 91G also has restrictions. Article 25 also is not absolute, it is also bound by certain restrictions. Article 29 also is bound by certain restrictions as have been enumerated in Article 11. So the council humbly submits that.
This council, you said that no fundamental right is possible,
Yes,
right? So there are certain reasonable restrictions.
Yes, Your Honor.
So better you give the reason that those reasonable restrictions have been qualified under.
Yes, Your Honor.
Take one by one.
Your Honor, so should I give the issue of maintainability? Just give me 2 seconds and I'll summarize the issue of maintainability. So we are saying that the fundamental rights have not been violated because they are absolute. State has the power to do so under the Act, NDPS Act, which is central legislation in itself. So there has been no violation of fundamental right. Whatever has happened as per the Maharashtra Prohibition Act. And the third one is an SLP that has been filed by Mr. X. So Your Honor, the petitioner's counsel Ms. Dibs have a right to violate. It is not a bail application. It is an anticipatory bail application. So the legal issue which has been framed by the court is.
Again, I have a question. In case of a state act or a fundamental right, if there are both overlapping, which will prevail? You say this is Maharashtra Prohibition Act, not the fundamental right. So if there are both the things, which will prevail? Fundamental right or Maharashtra Prohibition Act?
My Lord, Your Honor, the humble submission in this regard is that we have to see on the basis of the factual matter. Fundamental rights are supreme. They are in part 3 of the Constitution, and that's a very important, that's a part of basic structure of the Constitution. But no right is absolute. What we have to look into is the greatest interest of the public. We have to look at the public importance in this concern. Like whatever legislation we are having, is it impacting people directly, and what impact does it have? So that is how we classify a particular restriction as a reasonable one. So we will have to observe this particular inclusion of harm along with cannabis leaves under the Maharashtra Prohibition Act in this context. Whether the additional reason.
So when you say that petitions are not reasonable because there is no fundamental right which has been violated, so that is a decision of merits will take. But how do you say that the petition is not reasonable? How are we challenging the maintainability of the petition itself?
Your Honor, we are saying that the declaration is not maintainable because there is no violation of fundamental rights in the particular
But
law.
tell me, if judgment of High Court is to be challenged in number 36, what is wrong with that?
Your Honor, Mr. Z has not done. Mr. Z has not gone to High Court. He has approached directly to Supreme Court.
No, in summary of your argument, you are challenging all the petitions are not valid.
Yes, Your Honor.
No, if the High Court judgment is to be challenged, when will be challenged?
Your Honor, it depends. If it is a civil case, it will go under Article 132 of the Constitution of India. If it is a criminal case, it will go under 134. But here in this case, with regards to, since Mr. Z is talking about interpretation, when I am invoking Article 134, if the court is giving me the certificate to go, I can go directly to the Supreme Court. But in case it is not and I am agreed by the decision, I can, and if I have not been given certificate, I can go to the Supreme Court under Article 132.
So 136 they were approached, what's wrong with that? I'm just trying trying to understand how the first petition you are saying is not valid.
No, no, we are saying there is a substantial question of law in regards to this. We are saying that whatever has happened according to the procedure of the law.
His freedom is involved, why he can't go there?
My lord, there have been recent judgments where Supreme Court has said, the Supreme Court has said that not every petition has to be considered as an assembly. So there are certain things that we have to look into before granting an assembly. Just hearing of SLP does not make it and does not get it invoked and
See,
appellate.
what you are therefore saying is that on merits there is no question of law involved. Therefore, the SLP is not raising any substantial, so it is to be raised.
Yes.
But that will not go to the materiality part. Materiality is if I have to question, if the petitioner has to question the judgment of the High Court, then 136 gives them liberty to come to Supreme Court. Of course, it is the prerogative of the Supreme Court to grant or not to grant assent. There, the question of substantial question of law will arise. But as it is, what other remedy will they have?
My lord, Your Honor, could you clear the petition that one we are talking about? Is it Mr. Y?
Was first petition
So Your Honor, Mr. Y went to the High Court.
under 136. I am saying once the High Court has decided the petition, what remedy you mean to say that the petitioner will be remediless to challenge the judgment of the High Court?
Your Honor, it has the appellate jurisdiction. It can invoke the appellate jurisdiction under Article 134 or
Just to clear, you are saying he cannot invoke 136.
Your Honor, he can. He can, definitely can.
You are saying first under maintainability you are not doing.
I am.
It is on the SLP you are saying there is a direct repetition under 32 as well as in the first place there is SLP under 136, right? You are saying that he can invoke only appellate jurisdiction of Supreme Court or can he invoke a discretionary jurisdiction?
Your Honor, I think there is some confusion. So there are three petitions that have been cleared by the Honorable Supreme Court. The first one is Mr. Y versus the Union of Indiana. He has identified certain grey areas in NDPS Act which are concerning his punishment. So he has come to the court saying that these are substantial questions of law. What I as a petitioner.
There is 136. The
Yes.
first petition is under 136. That means the High Court has considered this question and High Court has not agreed with me.
No, Your Honor. I request you to come to page number 33 of the new proposition.
Yes.
So these questions were not raised before. Actually the petitioner has been aggrieved by the decision of the Honorable High Court and that is why he has come to
Para 34 you have
33 years.
Three petitions.
No.
Just a minute.
30 is except looking for anticipation.
So Your Honor, the Honor, panel number 21 of the new proposition.
Yes.
May I read it for the convenience of the
Yes.
court? Mr. Y challenged the proportionality of the punishment by saying that the fine and the term imposed upon him were very harsh compared to other legislations and that the court has unchecked wide and discretionary powers while imposing the punishment. So he is talking about the judgment of the Honorable High Court. He was convicted by the Sessions High Court, he was given the punishment, then he went to the High Court challenging his punishment. So the Honorable High Court has said that no, you can be given such punishment. And now he is quoting what exactly has been said by the.
Are you suggesting that these points have been raised for the first time before the Supreme Court?
Yes, Your Honor.
But being a question of law, can a fresh question of law not be raised before the Supreme Court?
Your Honor, it can be. Under Article 136, it can.
So 136 petition otherwise is mandatory.
In the present case, from the side of the respondent, I would say no, it is not. And because there is a substantial question of law, whatever has been done according to the
What
procedure.
remedy will they have if the punishment is violative of or the provisions of punishment? Because the punishment will come after the conviction. Where will they go and challenge it?
Your Honor, they could have forced the decision of the Honorable High Court, they could have come to the Supreme Court via
What
Article.
you mean to suggest is they should have challenged that before the High Court and then come before the Supreme Court.
Yes, Your Honor, that has been used.
But if, all right.
All right, Counselor, I also have a question.
Yes, sir.
You just said in your argument that he has list out certain gray areas and comes up with no such question of law. So it means you are agree that there are gray areas in the law of your government?
Your Honor, this is according to him. So when I was arguing, so I just put it in brief that not to mention all the sections, I use this word gray.
No. My question is, do you agree that there are gray areas in law?
No, Your Honor, I do not agree.
Yes,
I'm
ma'am.
saying he has identified according to him, not me. So the respondent side is very clear that there are no gray areas in the law. Whatever the punishment has been according to the provisions of the MPC.
All right, now move to the next issue.
Your Honor, my second issue is concerning Mr. Z, who is the petitioner. So he was actually a denied vendor, as I have already told that he was a vendor dealing.
Which issue exactly, 2 or 3?
It's actually, Your Honor, fourth
Fourth issue.
of the proposition, and if you go by the memorial, it is issue second. So I will read the issue for the convenience of the court. Whether section 65 B clause D, clause E, clause G of Maharashtra Prohibition Act 1949 are violative of Article 19 and 25 of the Constitution of Indiana, and the third one is whether the above mentioned sections and the punishment therein are violative of Article 29 of the Constitution of Indiana. So dealing with Article 19(1), we have already submitted that no right is absolute. It is also subject to restrictions. So here we are invoking the restrictions of public morality, decency with regards to it. So this right to self-harm, which is already a prohibited substance, that to be laced with cannabis leaves. The leaves have a certain substance that are very dangerous for the human health, and thus he cannot be allowed to exercise his right.
Counsel, when the substance has been used for a long period of time, it's not only in Doka village, but other places also, which this substance has been used occasionally on certain specific purpose. So how do you say that such practice should be curtailed under reasonable restrictions? Why do you say so?
Your Honor, I would request you to turn to paragraph number 15 of the memorial, page number 15 of the memorial. So there is this case in Chitra versus State of Tamil Nadu in August. The High Court of Madras referred to a survey that was conducted recently on the consumption of substances in India by Social Justice Empowerment Ministry in collaboration with AIM, which gave a key finding that more than 3.1 crore Indians are reported to be using cannabis products, bhang, ganja, charas, heroin, and opium. That the law concerning even them has to be very stringent. And with regards to its use, it's very long. That does not make it acceptable in today's time. For that, I request Your Honor to please refer to page number 19, paragraph number 24. So there
That's all right, counsel. But do you agree that there is difference between bhang, ganja and charas? All the three.
Yes, Your Honor, there is, but very marginal.
So we are discussing about the bhang,
Yes, sir.
consumption of bhang,
Laced with
on the
cannabis.
location of duty.
Yes, sir.
It's a religious practice also.
Yes, sir.
And also, in addition to that, Judge, there's nothing on record to show that there's a disgrace because of consumption on yearly festival. So how do you say that the consumption itself should be stopped or prohibited under the law?
Your Honor, we are not only concerned about the consumption. Mr. Z, the factual matrix says that Mr. Z, who is a petitioner, was also a vendor. So he is also protecting it under his Article 9. We are saying that it is not capable in any of the three circumstances. So just, Your Honor, dealing in crime cannot be a business. Dealing in crime cannot be a fundamental right, and this has been reiterated by this.
But how do you deal with Article 13(3)(a)? See, Article 13 says that if it is a custom, then state can't make laws contrary to that. To that extent, you see the use of the law, making this means use also prohibited. Will it not be violative of Article 13(3)? And this is 13(3).
Yes, Your Honor, I do know this article, but my answer to this would be this N article versus Travancore, there was no more than others. I request Your Honor to turn to page number. Your Honor, I request you to turn to page number 19 of the memorial. So there is this judgment by the Honorable Supreme Court itself which says that even if something has been very used, we have no proof with regards to its existence since when it started. But we know that it cannot be accepted in the present time, given the amount of illicit trafficking that is taking place and the amount of and the number of people who are consuming it is increasing. They are a big population. They are a very big population, and this particular festival is also identified to use.
you have not addressed anything about section 35, which was the main argument of the, from the.
Your Honor, that is to be dealt with by the court counsel. Those are another issues. She will be dealing with MBBS and the grave or the contentions that have been raised with regards to it. Whether section 35 of the presumption under it is constitutional or not, whether it is reasonable.
Also, when you cite in Aditya, okay, so I think it's a general ratio, but I think we also need to see the case specific, because here we are talking about usage of no other substance. So when you are applying this law, you also have to keep in mind the substance or the use that the privileged people have to do. So definitely there's a specific factor here.
Your Honor, I accept that, but why our view this judgment is very important? Because we want to look into something that has been going since time immemorial. So it can, just because it has been going on since time immemorial and has been accepted as a religious and cultural practice, can it be protected under the state legislation also, or should it be protected under state legislation? Because state legislation is in its jurisdiction under section 10 of the NDPS Act is exercised it. That is why it was made it. And the act was made itself very long in 1949. And that is why we are submitting, that is why we are using.
This criteria,
Your Honor, I have taken these words time immemorial from the law committee as made versus LCDNMCC. So there a fact was observed that even if something has been going since long, and we don't have any idea that when
no,
it's
there are specific codes in ancient Indian literature as well as in British era. You can quote something.
Your Honor, with regards to the mood proposition, we stuck to it that it has been a factor going on since immemorial. So we did not refer to the specific definition, and we have stuck to the dictionary meaning that
You
it
consider that established.
But suppose you see an practice which is, putting something in the words of code. Suppose a practice which is going on is otherwise bad. Let us say child marriage is bad. So state can make laws to prohibit that.
Yes, sir.
How do you put this particular practice as that social event?
Your Honor, I have already cited the survey that was observed in Chitra case where it was said that this particular, that there's a big population that has been consuming such amount of narcotic substances and the use of cannabis.
No, custom can be in a small community.
Yes, Your Honor.
It need not be. See, like, let me put it, in Punjab there are certain communities where there is custom called Chadar and Desi. Chadar and Desi is what, suppose you see wife of a person dies, then the sister of the wife, which is available, they are put and the husband are put under a chadar, and that is treated as a marriage. That is called chadar and Desi. So that's a custom in very few villages in Punjab. But a custom being followed by few people will not render custom as a custom. What do you think is that? You are saying that it is being followed by very few. It is not a test which will discard custom as a custom.
Your Honor, we are not submitting that it is being followed by the people. That is not a further submission. The submission is with regards to Mr. Z and the contention that he has made. That since we have been consuming it since long, it has become a part of us, you cannot ask us not to trade in it or not to deal in it. So the submission in this regard is that it has been made a consumption, selling or trading in it, even collecting of it has been made a criminal offence under the Maharashtra Prohibition Act. So it should be taken as it is. And as per the judgment of the Honorable Supreme Court itself in RMC Samarwal, it has been held that dealing in crime did not be a fundamental right. So with regards to the
Are you therefore suggesting they have not challenged this inclusion into Maharashtra state?
Yes.
Are you suggesting that the petitioners have not challenged the declaration of use of windmills as prohibited activity? That having not been challenged, therefore they are not affected.
That convention has not been, whether it has been challenged or not, you want to emphasize.
Your Honor, I don't understand.
I'm saying that your emphasis is that this Maharashtra Act, which has declared as in that particular state, that use of green leaves will also be treated as prohibited. Therefore, in Maharashtra, this is not permissible and they have not challenged it. That's why you are saying that they are not entitled for the benefit in Maharashtra.
Your Honor, I am not sure if they have challenged the inclusion or not because it was not in their arguments. What goes in our understanding is that it is prohibited under the Maharashtra Prohibition
No,
Act.
it is not in their argument, that's why that is your defense.
Yes, Your Honor. So,
This has to be your defense that since they have not challenged this declaration of law by Maharashtra law, therefore, this is an offense committed by them.
They are not
Yes,
This
entitled
is what
for
you are
it.
suggesting.
we could conclude this, Your Honor. We could conclude this.
All right, Council, that.
What they have to say that they celebrate it only, it is an annual event, they do it only for one and for this limited event. What is your take on it?
Your Honor, even if it is an annual event, it was attended by tourists also. So therefore, we contend that something, it is a criminal offence under the Maharashtra Prohibition Act. It does not say once, twice, or for the entire year. It says that even if it happens, you're caught doing it, so you have committed an offence. So he has committed an offence and he has been caught. He has been arrested under that.
And what do you have to say, there is a redundancy between the central legislation and the state amendments that are.
Your Honor, with regards to redundancy, I request you to turn to section 10 of the NPS Act. I would just.
No, that question of, exposure is very clear.
Hmm.
Talking about the redundancy between center act and state act. The answer in one word.
Your Honor, section 10 says that the states have the power to do so. So even in Assam, section 3 of the Assam Bhang and Ganja Act clearly prohibits the use, sale or purchase of bhang. So state legislatures have the power to do so under the central legislation itself. So there is no question of redundancy. Had such power not been allotted with regard to the use of cannabis, then you would have said that it is government. But the Learned Counsel for the petitioner has not raised this contention. And also we believe that prima facie there is no case of redundancy.
All right. Thank you.
Thank you.
Go, Council.
Second,
Which of the issues will be deliberated and discussed?
Your Honor, from the moment of position, I will be dealing with second, third, and sixth.
Second for 6.
May it please this court, this is the second counsel appeared on behalf of the respondent in the written case of Mr. Y versus State Tribunal and Mr. X versus the State of Mumbai, respectively. May I seek the permission of this honorable court to place my arguments? Your Honor, during my submission, I will be presenting facts and precedents to prove that firstly, the punishment prescribed by the NDPS Act is not arbitrary or violative of Article 14 and 21 of the Constitution of Haryana. And secondly, the presumption under Section 35 of the NDPS Act is not unconstitutional and does not violate Sections 14 and 21 of the Constitution of Haryana. And thirdly, that Section 37 of the NDPS Act to be held as a bar on the application of Section 438 of the CRPC. To begin with, the first issue, it is to be analyzed under Article 14 and 21 of the Constitution of Haryana. It is contended that the provisions to negate the arbitrariness, it has to pass through the arbitrariness formed in Article 14, and it must pass through two tests, that is the nexus test and the just, fair and reasonable. The council sees all.
Please go ahead.
It is mentioned in section in NT 77 of the notification act.
Entry 77.
Yes, sir. Morphine 400 grams comes under the commercial one. I would like to move further. In the present factual matrix, the alleged narcotic drugs were found in the vehicle driven by Mr. Y and was intercepted around the areas of St. Mary's College, which comes under the definition of an educational institute. Under section 32B, subclause D, I would like to open that. 32B subclause D, which enumerates the factors to be taken into account for imposing higher than the minimum punishment. Under clause D, it is written that the fact the offences is committed in an educational institute or near the vicinity of an educational institute, it must be given harsher or rigorous punishment. And my opposite counsel is saying that
there is an absence of factors enumerated. Here, there is no absence of factors because it clearly comes from the ambit of 32B subclause B. That is the reason such harsh and rigorous imprisonment has been given to the accused.
This first case where Mr. White was misrepresented by Mr. A, right? It's quite clear from the facts that Mr. White didn't know that what he's transporting. Second factor is that Mr. White also had to do certain things because of the COVID situation in which we have taken loan, this, that, money from Mr. A. So Mr. A has used Mr. Y, right? So when thereafter also you found that was a heroin of say 400 grams which you later on found to be morphine. So why why do you think that this harsh punishment what the petition is containing is justifiable, given the fact that Mr. Y didn't have clear knowledge, at least we can't see from the fact that he had knowledge of carrying, transporting 400 mg of morphine. What is your response?
Thank you, Your Honor. I would like to say that please refer to the moot preposition paragraph 13. It says that he would often supply psychotropic substances to different places. Mr. Y already knew that Mr. X has been dealing with psychotropic substances. Then, on his own will, he became a part and parcel of such a big nexus. So, we cannot.
Substance also can be used for the medicine purposes, right?
You know,
It's not
Your Honor,
always for
but-
illicit purposes.
Your Honor, thank you. I would like to say that ignorance of law cannot be claimed here because it cannot be said that you can plead ignorance here. Ignorance of law cannot be granted in this case. And I would like to say that he had a chance to leave the delivery job given that Mr. A.
We are not ignorance of law, we are ignorance of facts.
But ignorance of law has a much greater amplitude than ignorance of facts. So, in my case, ignorance of law has been gravely misused by.
So according to you, Mr. White knew that what he's carrying is prohibited substance under certain particular statute, despite that he carried it. But that's not clear from the evidence on record. You don't see that.
Your Honor, in the moot proposition, paragraph 13, it is written he would often supply psychotropic substance. He knew on the face of it, he had a knowledge of it. Though intention is not clear in this, but he had a knowledge. And to prove culpable mental state, knowledge is enough. So, in my case, he had a knowledge. Thus, he would be coming under the ambit that he transported from one place to another under the impression that he was transporting narcotic drugs. And of course, it is written in paragraph 13.
How he has done it?
He had knowledge, Your Honor, that he was supplying psychotropic substances.
Mr. Officer, when Mr. Y was specifically told not to tamper with the package, how do you establish that he had knowledge what was there inside the package? Do you mean to say that he had tampered the package and saw what is there inside?
No, Your Honor, he did not tamper the package, but such a large, like the 400 grams quantity is such a big deal. You have to apply your own mind.
I suppose Mr. Y has guessed what is there inside, like he has to see it. If it's not tampered, then how will he know what is there inside?
But he already knew that it was psychotropic substance. It could be used for.
No. He was just a carriage holder. He was carrying only, that is all. How he has knowledge? Somebody.
13 say, yes.
Your Honor, I would like to mention that paragraph 15 which says, however, all of that was merely a facade and Mr. Y was standing too close to see the actual picture which was forming, that of an organized crime and drug cartels, because he had a knowledge that Mr. X is a part of an organized crime and a big cartel.
Mr. Officer, so you agree that he is part of the cartel which is monitored by Mr. A?
Yes.
Has the state taken any action against Mr. A?
Your Honor, when I am reading this mentioning, dealing with only considering Mr. Y and X.
So it's not in the law?
Yes, sir.
That's fine. Yes, sir.
So So it is humbly submitted that the vehicle was intercepted near the immediate vicinity of St. Mary's College, which being an educational institute come under the subclause B of section 32B of the NDPS Act. Thus the punishment is justified and does not curtail the liberty of the accused under Article 21 of the Constitution of India. Now I would like to proceed with issue 5th, that is whether the presumption under section 35 of the NDPS Act is unconstitutional as being violative of Article 14 and 21 of the Constitution of India. I would like to say NDPS is a special legislation containing stringent provisions. The acts being draconian are stringent and needs to be treated differently from the other laws or the contrasting general laws. In Hiten P. Dalal v. Rabindranath Banerjee and Ms. M.S. Narayana Menon, it was held that legal provisions does not become unconstitutional only because it provides for a reverse burden clause. The question as regards of burden of the proof is procedural in nature. So, the reverse burden clause, that is, the accused has to prove his innocence beyond reasonable doubt, has been given as a measure to prove his innocence by Mr. Y to prove his innocence. So he cannot say that we did not possess a culpable mental state, or he cannot challenge it under Article 14 and 21 of the Constitution of India. Now I would like to further say that Section 35 does not violate Article 14 and 21 of the Constitution of Haryana, as in the landmark judgment of Noor Agha v. State of Punjab, it was declared that Section 35 is non-under bias of Constitution of India and does not violate Article 14 and 21 of the Constitution. Mr. Y did have the conscious possession in culpable mental state. As
Conscience, I have a question. That Noor Agha, it was different that, and your case is different.
Your Honor, Your Honor, it is also dealing with NDPS Act.
It is in India, but what are the
Heroin, the person was intercepted with heroin of I think 1 kg. Your Honor. I'm not sure of that, but it comes under the NDPS Act, the same Noor Agha case, and there also the constitutionality of Section 35 was challenged under Article 14 and 21 of the Constitution of India. So, and there it was declared that it does not violate, Section 35 of the NDPS Act does not violate Article 14 and 21 of the Constitution of India. That is why it comes under the landmark judgment of my case, and that is the reason I would like to say that it does not.
in the same way this court would like to supply all the cases. That's why I asked you. You have to prove.
In Ram Singh versus Central Bureau of Narcotics, it was observed once an article is found in possession of an accused, it cannot be presumed that he was it could be presumed that he was in a conscious possession. So Mr. Mr. Y was in the conscious possession of the alleged narcotics drugs, as he was in his vehicle he was having the 400 grams of morphine. The onus of proof under Section 35 is on the accused to prove his innocence, and the burden of proof shifts from prosecution to accused. So the accused does not possess a culpable mental state, as he became a part of the organized crime syndicate and knew from the face of it that he had been transferring goods from one place to another under the purview of narcotics and psychotropic substances. Now I would like to move forward with issue 6, that is whether Section 37 of the NDPS Act bars the application of Section 458 of the CRPC. The response to this question is affirmative, as it is a settled position of law that NDPS is a special law, and special law always prevails over general law. As held in the case of Sharad Babu Bidu Hadid versus Government of LCD of Delhi, NDPS is special legislation. It is different from the criminal substantive laws and has provided for mechanism for procuring bail within its own ambit. That means that Section 37 provides for bail or anticipatory bail under its own mechanism. It does not have to refer to.
If accused has to approach court for anticipatory bail, under which provision the accused shall proceed?
NDPS.
For anticipatory bail.
Under NDPS.
It can be anything, any crime.
In general laws, it has to be dealt with the. For anticipatory bail, 428 has to be applied, CRPC. But as NDPS is a special legislation, it is stringent in nature and
and it is draconian.
So
it has
are
to
you
be
saying
dealt
that,
differently.
are you saying that Mr. X has to file a petition before the High Court under 37 for admissibility bail? Is it your case?
Yes, Your Honor. I am just saying that Section 37 of the NDPS Act bars the application of 438. 438 cannot be applied in case of Section 37. As there is a non-obstante clause mentioning in Section 37, which begins with that notwithstanding anything contained in CRPC. So it totally says that CRPC has not to be included in NDPS cases. So that is my issue.
CRPC is a different thing, it's a complete comprehensive code, but 438 can be good, why not?
Your Honor, only after satisfying with the two clauses, that is, the PP has to be satisfied to oppose the application to such release. And secondly, when the PP opposes the application, the court is satisfied that there are reasonable grounds to believe that he is not guilty of such offence and that he is not likely to commit any offence via the bail. So
That is why
basically,
he is challenging.
yes, sir. That is why I am saying that bail has been given in NDPS differently and it cannot look into CRPC because it is restricted by this clause that is notwithstanding anything contained in the CRPC.
Mr. Counsel, if someone is approached under 438, why do you say that the court will not look into the parameters of the 438?
Because of the non-obstante clause, Your Honor. Because it restricts the application of 438 CRPC. So therefore, the High Court of Mumbai has rightly rejected the anticipatory bail application under section 438 of the CRPC. That concludes my submission. I would like to proceed with the.
No, I have a question for you.
Bail is a fundamental right.
Yes, Your Honor, bail is a fundamental right. But granting of bail is upon the discretion of the court. Yes.
Okay, so I have a question for you. So you are saying you have charged Mr. X. Don't you think it is the company who is the owner of the port where the ships are coming? So how you have charged him only and not company? Are you able to prove that he is the one who was in the direct knowledge and he was the one who was operating the port?
Thank you, Your Honor. I would like to say that it has to be considered on the basis of constructive possession. Mr. X is the owner of, such a big business tycoon and he owns all the airports and ports which comes under his jurisdiction. So whenever the ship a 5 kg of illegal cocaine has been
So why
intercepted,
only he must be a director in the company? So why only he is being charged? Why not every other?
because he represents the whole company, Your Honor.
Ms. Counsel, my sister, it is absolutely correct when she's saying that why him, why Mr. X? Do you have anything to show that he's the managing director of the company? You don't have. He's the business guy. You were saying it's fine, but is he running the day-to-day business affairs of the company? I don't think so. So then why you are after Mr. X and not the carriage, the transporter? Why you are against the dock owner or the port owner?
Your Honor, again, I would like to say that can I please take this?
Okay, thank you, Rohan. Relax now.
Your Honor, I would like to again say that it is a constructive possession and as in the recent case of Aryan Khan, where it was imputed on Aryan Khan being charged while his friend who was Albaz merchant was having the possession of all the narcotic drugs. Even after that, Aryan Khan was being jailed.
All right,
That is it.
come on.
Alright, come rejoinder, who is doing?
Your Honor, may I proceed with the prayer?
Please proceed with the prayer.
Wherefore, in the lights of the facts stated, arguments advanced and authorities cited, it is most humbly prayed and implored before the Honorable Supreme Court of Indiana that it may be graciously pleased to adjudge and declare that all the petitions to be held not vindicable, that the punishment prescribed by the NDPS Act be held neither arbitrary nor violative of Article 14 and 21 of the Constitution of Indiana. Thirdly, that the presumption under Section 35 of the NDPS Act be held constitutional and non-violative of Article 14 and 21 of the Constitution of Indiana, and that the punishment prescribed under Section 65B, E and G of Maharashtra Prohibition Act be held non-violative of Article 19,
25 and 29 of the Constitution of Indiana and in section 37 to be held as a bar on the application of section 428 of the CRPC. Also to pass any other order that the Honorable Supreme Court may deem fit in the favor of respondents to meet the ends of equity, justice and good conscience. For the act of kindness, the respondent shall be duly found forever. Thank you so much. It was an honor to present. The council seeks permission for those acts.
Yes.
Much obliged, Your Lordship. The council seeks permission for the. Your Lordship, it is humbly submitted that in the issue 1, that is of maintainability, the existence of substantial question of law is present in our case. Hence, because 32B are not met and the conscious possession is also not justified, that is clarified by the council itself. Secondly, fundamental rights have been violated and grounds stated for reasonable restriction by the respondents considers decency, and in nowhere in the Act and the fundamental rights the decency is considered as a reasonable restriction. Hence, they are violating the fundamental rights of the petitioner, reasonably restricting on any arbitrary provision that is decency.
This you have already argued and established. Anything new if you want to say, that will come up.
Indeed, Your Lordship. Your Lordship, in issue number 2, the vicinity is again justified by us. Further, in issue number 3, reverse burden of proof that the respondents have contested in the case of Nooragha. In the similar case itself, in Nooragha, it was stated that the initial burden of proof rests with the prosecution, that it first has to establish the beyond prima facie grounds that the accused is culpable of the said charges. After that, the reverse burden of proof is granted. And hence, here they clearly failed to establish something prima facie ground. Coming to the conscious possession, Your Lordship, they talk about case of Ram Singh versus NCB, where the conscious possession has been talked about. Your Lordship, in a very similar case, Avtar Singh was state of Punjab. It was stated by the court that the person may be sitting on a gully bags. In the absence of proof, anything more than presumed to be in possession of goods, it cannot be assumed that he had a culpable mental state. Therefore, similarly, in our case, the consignment have to be delivered untempered. Therefore, it cannot be conferred that he had a conscious possession. Further, concerning issue 4 and 5, the rights are not mutually exclusive. That is conferred by the respondents. However, fundamental rights are mutually exclusive, which has been affirmed by this court and also in the case of Madhu Kishore versus State of Bihar. Further, they are charging the petitioner under 65 clause G, which talks about the cultivation, and they nowhere have justified what is cultivation. Further, the council would like to give to the court's notice that cultivation of bhang is a natural process and it grows in the wild. Therefore, cultivation cannot be removed. Further, coming to the issue number 6, first of all, they have come to this honorable court with the wrong because the Mr. X has filed a writ petition, while what respondents have argued is an SLP. Therefore, on face of it, it stands dismissed. Therefore, the counsel for the petitioner argues that the court should adjust the matter in favor of the petitioner and be pleased to adjust in the
All right.
Thank
Take
you.
a consideration. Sir?
I'll be very quick, my lord. With regards to issue 1, the contention has been raised that we are not, they have raised that we have nowhere proof that it was an indecent act or whatever.
Decency is not even a restriction. What we are concerned with is public order, health, morality, and social reform under various articles. We are also talking about general public importance in the present case. With regards to issue 2, they have pointed out the presumption is not there. Your Honor, NDP is a special legislation. It is a special legislation. That is why the onus to prove that you are innocent is on the accused. There is a presumption because they are dealing with a very heinous crime. It cannot be treated like a normal offense because it is concerned with the greater interest of public. It is just concerned with society. The person was carrying 400 grams of the prohibited drug, and it cannot be asked that he was not having an intention or whatever. He was very well aware that he is doing something for somebody. He has no idea. He has not taken any this description about the job or whatever, he is taking it, he is carrying it. And most importantly, nowhere have they challenged the conviction under the act. What they are challenging is the punishment. They have failed to establish that the conviction was incorrect. They have been constantly arguing on the punishment, so conviction nowhere becomes a point. Issue third is, with regards to this point, without concerning to other circumstances, he was not a man who was picked from the street, he was not a villager, he was a tuition teacher living in a city. And the faction also says that, there were circumstances where, given his background, it is impossible to believe that he could not have no idea about the modus operandi. And moreover, he was intercepted near an educational institution. So if they are arguing that there were no other factors, he has been caught from an educational institution, he has been caught near St. Mary's College. And that is what the NDPS Act aims to prohibit. It aims to prohibit the consumption of narcotics and psychotropic substances, especially among the youth. That is why the provisions of NDPS Act are so stringent. And with regard to 65G, the learned council has failed to understand the relevant section. The section is not only concerned with cultivation. We do accept that cultivation is natural in the land. The topography of the land, the soil of the land allows for it to naturally grow. But we are concerned with the collection of hemp. Section 65G talks about collection as well as collection or cultivation. There is an all here. If the learned council for the petition has somehow missed it, so we are saying that as a vendor he collected hemp, he collected the prohibited parts, made thandai with cannabis seeds, and thus he has committed a criminal offence. And third point is that Mr. X has not filed a writ. He is not saying that the Article 21 has been fundamentally violated. The legal issue in the moot proposition itself is whether Section 37 bars the application of Section 438. 438 is about anticipatory bail, Section 37 talks about bail. So we are saying that NDPS is a stringent provision. It does not allow for bail, anticipatory bail under Section 438. Whatever bail can be given to him, it can be given under Section 37. That is what we are arguing. So it is not a writ, my lord. There is a substantial question of law. That is why respondents believe that it has come under SLP, not a writ petition. The council has failed to establish that Article 21 has been violated. There is no charge, there is no trial. He just sought for an anticipatory bail. We denied it. The Honorable High Court said in paragraph number 33 that anticipatory cannot be given. It is completely hard under the NDPS Act. That is why we are not giving. The petitioner, Mr. X, is not facing any trial, nothing. He is just apprehending arrest. That is why he has come to the court. So it is not a writ petition, Your Honor. The learned counsel for the petitioners has erred in understanding this point of fact, and the legal issue is it. That's it, Your
Let me
Honor.
just put one hypothetical question to you.
Yes,
If
ma'am.
this is first case, the incident is on 16 December, right? At that time, there were COVID restrictions, educational institutions were closed. So what would be the stand of government saying that by the government order, it was not an educational institution was closed, and since you have not made Mr. A as the co-accused, don't you think that stringent provision should not apply?
Your Honor, let me bring you notice again that he is concerned about Mr. A. Mr. Y has not even challenged the conviction. He has said the
What
punishment.
is your duty? If there is a poor man, so you want to convict, you say that he is the one who is working for the cartel, right? He is the one who is organizing, and isn't that your duty as a prosecution to prosecute him?
Your Honor, it is our duty as soon as we get the evidence, as soon as
Is it
the
his
complaint
duty
is
to
filed.
make him a accused, to challenge that? Or
Your Honor, we should-
the prosecution.
Your Honor, going beyond the moot proposition, if I submit my opinion, I would believe that this case needs further investigation. Of course, we have something with regards to Mr. White. We have got some idea that Mr. A is operating a drug cartel. So he can be used as a witness, some more evidence can be collected. We can do that. But in the present case, in the legal issues claimed before us, we are no more concerned with the conviction. We are only concerned with whether the punishment is arbitrary, whether the culpable mental state that is presumed is correct or not, it is violative of fundamental rights or not. So the learned counsel for the petitioners has failed to understand that what exactly we are contending here in the. That is it. Thank you so much.
Right.